Adam Winkler is joining us. He's professor of constitutional law at the UCLA School of Law. He's also author of the book Gunfight, The Battle Over the Right to Bear Arms in America. Adam has an article about the George Zimmerman case in Huffington Post, which I recommend you take a look at. Adam, it's great to talk to you again. I think the good place to start is, what is going to be the crux of getting a second-degree murder conviction on George Zimmerman? Is it going to be the stand your ground law? Is that actually going to become secondary? Give us a sense of that.
Well, I think the stand your ground law is going to have its greatest influence when George Zimmerman has a pretrial hearing to see whether the charges will stick. You know, usually you can argue self-defense in any kind of homicide case. However, that goes to the jury, and the jury decides whether you had a reasonable belief that deadly force was necessary. The real innovation of the stand your ground laws is not so much the extension of the right of self-defense onto the street, what most people have been talking about, but the addition of a new procedural opportunity for a defendant to show before he ever gets to a jury that he was acting in self-defense and that the charges should be dropped.
Okay, so the stand your ground law itself will actually come up not during the trial itself, but before the trial, there could actually be a decision made that, and this is just based on a preponderance of evidence, right? Not beyond a reasonable doubt that this was self-defense, and then in that case, the stand your ground law could preclude this from even getting to a trial?
That's right. The stand your ground law really is an innovation, much less in extending the right of self-defense onto the street, and much more in creating procedural opportunities for defendants to avoid having to go to trial whatsoever.
Let's say that this goes to trial, right? The stand your ground law doesn't prevent this from going to trial. Is this going to be a difficult case to get a second-degree murder conviction on? What's the best path that you see for prosecutors here?
I think the prosecutors are going to have a tough time with this case, in part for the same reasons that Americans are debating what happened this evening. It's going to be very difficult to recreate exactly what was on George Zimmerman's mind when he shot Trayvon Martin. There's apparently some conflicting witness accounts about who was beating who and who was on top in this struggle that the two of them had, and that's really going to matter. And any reasonable doubt, of course, goes in George Zimmerman's favor.
Okay, so if you were Zimmerman, you would not recommend, if you were his attorney, that he simply throw himself on the mercy of the court and say, I did it, it was a huge mistake, please have mercy on me. You think he actually can fight this one very well?
Well, I don't think any good lawyer is going to tell a client facing a murder charge, just apologize and say it was a mistake, that you're going to get leniency for that.
Right.
That's basically admitting to guilt. And from everything we know, it seems that George Zimmerman believes that he is innocent of the charges and that he was reasonably acting in self-defense. I don't know if that's quite the truth in terms of the real facts on the ground, but we'll find out soon enough.
Okay, you talked about this issue of who was on top during this altercation. It would seem that with a claim of such close-range shooting, and if it was indeed Trayvon Martin who was on top attacking George Zimmerman, that would lead to some pretty specific evidence when it comes to the wounds and blood, etc. Is that going to be a big part of this trial, do you believe?
I would expect there to be a lot of attention to the nature of Trayvon Martin's wound, where the gun was fired from, whether it was fired from someone standing on top of him or someone from below him. Obviously, the forensics will be very detailed and will provide real insight, I think, into what was happening that night when the shot was fired.
I always think about, in these cases, there's so much of a discussion in the media about, can there be a fair trial? Can you get an untainted jury pool? And eventually, invariably, prosecutors and defense attorneys do agree on a jury, right? But I always am left wondering, what does it really mean that they are untainted? This is a case where, let's expand beyond just Sanford. All of Florida, all of this country has been following this case for the most part already for several months. How do you handle that, and does that help the defense or does that help the prosecution?
I think it's going to be a real challenge for the court and also for both sides in this case. Neither side wants to have a biased jury because you don't know which direction they're going to be biased. Just think of how divided Americans are about this Trayvon Martin incident. There's a lot of people who are firmly convinced that he's guilty and a lot of people that are firmly convinced he was acting in reasonable self-defense. So any kind of bias is a challenge for everyone. I think that what's going to happen is what usually happens is that we find a jury not necessarily that hasn't heard anything about the case, but just one that can seem reasonably capable of making an unbiased, untainted judgment about the facts presented in trial.
Give us a little bit of insight logistically. If you're building a defense here, if you're George Zimmerman's attorney, how do you start? In other words, there's so many options where you can organize your narrative in so many ways, right? How do you figure out how to start building the narrative you want to present to the jury? I mean, give us a sense of how that might actually work.
Well, I think one of the key things that they're going to have to do is to explain why George Zimmerman was chasing after Trayvon Martin that night. Even if it turns out that that chase ended and then Trayvon Martin then subsequently attacked George Zimmerman, I think one of the key pieces of evidence will be what was his motivation, George Zimmerman's motivation, for chasing after Trayvon Martin that night. That's going to help shape the jury's understanding of what he was thinking when that altercation occurred.
Sure, and many of the defenders of George Zimmerman are saying, hey, he wasn't really following when the 911 operator said, we don't need you to do that. He said okay, and that was it. The reality is that several minutes later, after Trayvon Martin had been running, George Zimmerman could still see him. How could he still be within visible distance of Trayvon? Did he actually stop following at that moment? It's not really adding up for me, but I'm sure it will come out in the case.
That's right. And we also have this evidence, this testimony that might come out from Trayvon Martin's girlfriend or friend who was on the phone with him at the time. And it sounds from her report that Trayvon Martin was followed by George Zimmerman and that George Zimmerman confronted Trayvon Martin at some point before a phone was dropped. So we have a lot of open questions about what the facts were that night. And of course, in a murder trial, the facts are going to be so important in figuring out whether George Zimmerman will be convicted or not.
Adam Winkler is a professor of constitutional law at the UCLA School of Law. You can also find his latest article about the George Zimmerman case at HuffingtonPost.com. Adam, always a pleasure to talk to you, and we'll definitely have you back as the trial continues.
Thanks so much.